Module 6. Law Enforcement and Criminal Evidence. Law enforcement and criminal evidence. A cornerstone of justice. Law enforcement and criminal evidence are fundamental elements of the justice system, working in tandem to ensure accountability, fairness, and public safety. At the heart of law enforcement's role lies the responsibility to investigate crimes, uphold the law, and maintain order in society. Evidence is the cornerstone of these efforts, providing the factual basis necessary to prove or disprove allegations within the legal framework. The relationship between law enforcement and evidence is intricate, requiring meticulous adherence to established procedures and ethical standards. The collection and preservation of evidence demands skill and precision. Whether physical, digital, or testimonial, evidence must be gathered in a manner that respects constitutional protections, such as those against unlawful search and seizure. Law enforcement officers must balance investigative urgency with the duty to safeguard individual rights, ensuring evidence remains admissible in court. Chain of custody protocols, forensic analyses, and documentation are essential to maintaining the integrity of evidence. Understanding entrapment. When does it occur? Entrapment is a legal defense used in criminal cases when an individual argues that law enforcement induced or coerced them into committing a crime they would not have otherwise committed. This concept centers on fairness in the justice system, ensuring that government officials do not improperly influence individuals to violate the law. Entrapment occurs when law enforcement officers or agents actively persuade, pressure, or encourage a person to commit an unlawful act, and the individual can demonstrate that the idea of committing the crime originated with the officers rather than themselves. It is not merely a matter of opportunity. Offering an individual a chance to commit a crime does not constitute entrapment if the person is already predisposed to engaging in such illegal behavior. The key distinction lies in whether the individual acted voluntarily or was unfairly manipulated. Courts evaluate entrapment claims by considering the conduct of law enforcement and the defendant's intent or predisposition. For instance, entrapment may be argued if an officer provides excessive inducement, such as repeated coercion, deception, or promises of financial reward, and the defendant lacks a criminal inclination. However, merely setting a trap for someone already inclined to commit a crime does not meet this threshold. Terry v. Ohio. Expanding police authority through stop and frisk. The landmark Supreme Court case Terry v. Ohio, 1968, established a significant precedent in criminal procedure, granting police officers the authority to stop and frisk individuals based on reasonable suspicion of criminal activity. This decision allowed officers to conduct a brief investigatory stop and, if necessary, a limited search for weapons without a warrant or probable cause to arrest. The court's ruling was rooted in the Fourth Amendment, balancing individual rights against public safety concerns. The case arose when Officer Martin McFadden observed suspicious behavior by 3 individuals in downtown Cleveland. Believing they were planning a robbery, he approached them and conducted a pat-down search, discovering concealed weapons. The court upheld the officer's actions, emphasizing that the Fourth Amendment protects against unreasonable searches and seizures, but does not preclude limited searches for the safety of the officer and the public. Admissibility of evidence regarding bar presence in vehicular homicide trials. In a trial for vehicular homicide involving allegations of drunk driving, the jury's awareness of the defendant's presence at a bar before the incident raises complex legal considerations. Central to this issue is the principle of relevance under the rules of evidence. Evidence about the defendant being in a bar may be deemed admissible if it establishes or contributes to establishing a material fact, such as the likelihood of alcohol consumption and its role in the defendant's impairment at the time of the crime. However, mere presence at a bar does not prove intoxication or guilt, and its admission must be weighed against potential prejudice. Courts typically evaluate whether such evidence unfairly influences the jury by creating assumptions about the defendant's character or behavior unrelated to the specific allegations. The prosecution must demonstrate that the information directly supports their case, such as through additional evidence showing alcohol consumption at the bar and its connection to the defendant's impairment. Without such linkage, the defense may argue that the information is speculative and serves only to bias the jury. When statements made during plea negotiations are not excluded under Rule 410, Rule 410 of the Federal Rules of Evidence generally protects statements made during plea negotiations from being admitted as evidence against a defendant. This rule promotes candid dialogue between defendants and prosecutors, fostering the possibility of plea agreements vital to the judicial system's efficiency. However, there are specific circumstances where statements made during such negotiations are not shielded by Rule 410. One such exception occurs when the statement is introduced in a criminal proceeding to refute a claim of prosecutorial misconduct. Suppose the defendant alleges that the prosecutor engaged in improper conduct during the plea discussions. In that case, the court may allow the prosecution to present statements from those negotiations to demonstrate their propriety. Another exception arises when a defendant knowingly and voluntarily waives their Rule 410 protections. Such waivers are typically part of the plea agreement process, allowing prosecutors to use the defendant's statements in later proceedings if the plea agreement is breached. Courts carefully scrutinize these waivers to ensure they are made voluntarily and with a complete understanding of their implications. Additionally, if statements made during plea negotiations are repeated outside the protected context, such as to a third party, they may lose their Rule 410 protections and become admissible. Understanding out-of-court statements. An out-of-court statement refers to any assertion or declaration made by an individual outside the formal setting of a courtroom. These statements are not presented directly during trial testimony, but may become relevant to legal proceedings when introduced as evidence. The significance of such statements arises primarily in the context of hearsay rules, which govern their admissibility in court. Out-of-court statements are typically offered to demonstrate the truth of the asserted matter or provide context in specific cases. For example, a witness may recount a conversation they overheard, or a document created outside legal proceedings might be presented. The challenge with these statements lies in their reliability, as they have yet to be subjected to the scrutiny of cross-examination. Courts often evaluate the credibility and admissibility of such statements using well-defined exceptions to the hearsay rule, including circumstances where the report reflects a spontaneous utterance, a party admission, or fits another recognized exception. Understanding spousal confidential communications privilege. The spousal confidential communications privilege is a legal protection that safeguards private exchanges between married partners from being disclosed in legal proceedings without consent. For this privilege to apply, the communication must meet specific criteria to qualify as confidential. A communication is considered confidential if made during a valid marriage and intended to be private. The essence of this privilege lies in the presumption that marital conversations foster trust and openness, vital to the sanctity of the marriage bond. Not all exchanges between spouses qualify for this privilege. The communication must be expressly or implicitly intended to remain private. For instance, a conversation held in public or the presence of a third party typically falls outside the scope of the privilege, as privacy is neither present nor presumed. The privilege also does not extend to communications related to future crimes or fraudulent activities, as public policy dictates that such interactions cannot be shielded under the guise of marital privacy. The nature of truth. Proving a fact without evidence. Proving a fact without directly presenting evidence relies on the interplay of logical reasoning, foundational principles, and shared understanding. In many contexts, facts are established through deductive reasoning, where a conclusion is logically drawn from general premises that are already accepted as accurate. For instance, mathematical proofs often demonstrate truths through logical sequences rather than empirical evidence. This process underscores the power of reasoning to validate a fact when direct evidence is inaccessible or unnecessary. Another method involves leveraging universally acknowledged axioms or principles. In science, for example, specific laws, such as energy conservation, are so deeply rooted in observation and theory that they form the basis of arguments without needing constant reproof. A fact derived from these principles is accepted due to the reliability of the foundation upon which it rests. Language and definitions also play a crucial role. Facts rooted in a system's semantics, such as definitions in geometry or grammar, are often proven through internal consistency. For instance, in linguistics, the grammatical correctness of a sentence can be established by adhering to rules rather than presenting external evidence. Facilitating evidence presentation. The impact of Rule 1003's exception to the best evidence rule. The best evidence rule traditionally requires the original document to be presented in court to ensure the reliability and authenticity of evidence. However, Rule 1003 creates an exception, allowing the use of duplicates in place of originals under certain conditions. This exception significantly simplifies presenting objective evidence in trials, reducing procedural barriers and enhancing judicial efficiency. Rule 1003 acknowledges the practical challenges of securing and preserving original documents by permitting duplicates. Many legal disputes involve records stored electronically or documents that are geographically inaccessible or at risk of damage. Allowing duplicates alleviates the burden of retrieving originals while maintaining the evidentiary value, provided there is no question about the document's authenticity or fairness in its admission. This exception also minimizes delays caused by logistical issues and safeguards the integrity of the original documents, which may be critical for future reference or ongoing litigation. The exception to the best evidence rule under Rule 1003 emphasizes fairness and pragmatism, ensuring that rigid formalities do not unduly hinder the search for truth in legal proceedings. While protecting against fraud or misrepresentation remains paramount, eliminating duplicates strikes a balance between procedural rigor and the practicalities of modern evidence management. This flexibility fosters a more accessible and equitable judicial process, enabling parties to focus on substantive justice rather than procedural obstacles. Thus, Rule 1003's exception streamlines evidence presentation while preserving the integrity of the legal process.